Our analysis of performance standards continues in this screencast lecture that introduces the topic of exclusive dealing contracts. Let's begin with the origins of the common law treatment of these agreements. In Wood v. Lucy Lady Duff Gordon, the renowned lady argues that her exclusive arrangement with Wood lacks mutuality of obligation. Although we all survived the movie, Lucy's celebrity included being a survivor of the actual sinking of the Titanic. She claims here that Wood isn't bound to do anything, and that fact implies he's provided no consideration. This was a common argument about such deals in the 19th and early 20th century. The textbook quotes Carl Llewellyn, who was the main author of the UCC. He asks whether Otis Wood should, while carefully avoiding all risk in the event of failure, nevertheless claim full profit in the event the market may prove favorable in its response. We've seen in prior cases like Varney and Jacob and Youngs against Kent that Judge Cardozo can be creative in finding implied duties or conditions. In Wood, he uses similar methods to solve the problem of consideration. What's the solution that he offers here? Please pause the video now to write down your answer to this question. As you read, Cardozo finds an implied duty to use reasonable efforts to promote Lucy's designs and her endorsements on the designs of others. In paragraph 4, he says that the acceptance of the exclusive agency was an assumption of its duties. Wood's promise to pay half the profits was a promise to use reasonable efforts to bring profits into existence. The opinion shows Judge Cardozo at his finest. In yet another famous phrase, he says that a writing is instinct with an obligation imperfectly expressed. The idea here is that if you grant exclusive rights, then you presumably expect to get something in return. Remember that Cardozo found an implied condition in Jacob and Youngs against Kent that substantial performance would be accepted. Wood's implied duty here fills a gap just like the implied duties and conditions found for an offer of unilateral contract and for reliance on a firm offer, and in Taylor against Caldwell, excusing performance. The UCC formalizes the same implied duty in Section 2306 as an obligation for the grantee of exclusive rights to make best efforts under the contract. But we're left with a question of what this general best efforts standard really means. Let's consider briefly what both Wood and Bloor have to say about this question. In Wood, we've seen that the court found an implied duty to use reasonable efforts. But what exactly does that mean? What does it require? It's not at all clear. It certainly means at least some effort in order to be consideration for the promise of exclusive rights. So Wood implies that reasonable effort requires some effort on the agent's part. What about the more complicated case of Bloor against Falstaff? Let's boil it down to the essentials. Basically, Ballantine was losing a lot of money and sold its labels to Falstaff for $4 million plus a royalty of 50 cents on each barrel sold under the Ballantine labels. Falstaff continued to lose even more money. They claim to have lost $22 million on Ballantine operations between March of '72 and June of 1975. Falstaff was then taken over by a businessman named Paul Kalmanovitz. Mr. K adopted a new distribution strategy. He said, "We sell beer and you pay for it. We sell beer FOB the brewery. You come and get it." There are two claims raised by Bloor, the trustee in reorganization for Balco, which was formerly Ballantine Company. Conveniently, all three names start with a B. First, Falstaff breached the best efforts clause by failing to maintain a high volume of Ballantine label sales. And second, Falstaff substantially discontinued distribution of Ballantine and thus triggered the liquidated damages clause. If so, they must pay $1.1 million per year for the rest of the royalty period. Bloor argues that Mr. K's new come and get it policy was discontinuation. But as you read, Judge Friendly rejects this argument. He points out that distribution is commonly understood to mean selling the product. It doesn't necessarily entail trucking the beer around the country, and Falstaff sold lots of Ballantine, 500,000 barrels of beer. Scott Phillips, a former contract student of mine, calculated that that would be 377 beers per law student per day. That's not substantial discontinuance. So if Falstaff didn't substantially discontinue distribution, what did the company do wrong? The district court relied on 7 factual findings, described in paragraph 10 of the court's opinion. They closed the North Bergen depot, they chose distributors who owned a competing brand, they declined Guinness's offer to distribute, they devoted greater effort to the sales of their own brands, they failed to treat Falstaff and Ballantine brands equally, they discontinued sales goals for salesmen, and finally, Mr. K's plan stressed profit at the expense of volume, or profit über alles. The appellate court notes Falstaff's barrage leveled against the trial court's factual findings, and acknowledges that Texas and Missouri advertising and pricing strategies did not show favoritism, which the district court had inferred. So, which was the most important of these facts? I think it's clearly number 7, that the Mr. K plan that focused solely on Falstaff profits. Judge Friendly upholds Judge Bryant's ultimate conclusion that Falstaff breached the best efforts clause. But if Falstaff didn't do enough, what did the best efforts clause require? Please pause the video now to think about this question. Review the opinion and see if you can find specific textual evidence that tells us what Falstaff did and did not need to do. This is a subtle question that clearly troubled Judge Friendly deeply. He points out that the law is a mess and that it's a shame a federal court has to decide what state law requires. Ultimately, he concludes that the clause didn't require Falstaff to spend itself into bankruptcy to promote Ballantine sales. This principle arises from and is consistent with the ruling in the breadcrumb case of Feld against Henry S. Levy that's discussed in paragraph 7. However, the best efforts clause did require that Falstaff consider taking some steps to maintain a higher volume of Ballantine sales. They must give fair consideration to Ballantine's interests. Thus, the Mr. K plan is not necessarily okay, though it might be. This is a fairly weak standard of performance. Bloor implies that best efforts requires at least fair consideration of Ballantine's interests. But only an extreme breach is likely to be actionable under this standard. The surprising weakness and uncertainty of the best efforts standard raises the question of why parties enter into exclusive dealing arrangements rather than simply selling to all comers. The purpose of granting exclusive rights is to protect the investments that the exclusive agent makes. In Wood, that's promoting the sale of Lucy's name and products. In Bloor, that's promoting the sale of Ballantine beer. And in Van Valkenburg, which is discussed in Bloor, the agent is publishing and selling the books. But as these same cases make clear, parties who grant exclusive rights have a problem. The exclusive agent doesn't get all of the gains from its promotional efforts, and the agent might sometimes even gain by taking away customers, as in the case of selling a competing electronics book in Van Valkenburg. The agent's incentives aren't perfectly aligned with the interests of the grantor of exclusive rights. The agent has some incentive to shirk, to devote insufficient effort to promoting the product. This is a generic problem that potentially affects any contract that uses profit sharing, royalties, or commissions to compensate agents. As the textbook explains, Professors Getz and Scott have an answer. They argue that the most efficient default rule requires the agent to behave as though both parties to the contract were part of the same company, like a joint venture. They propose a standard of joint maximization. In theory, this rule maximizes the size of the pie to be divided between the parties. And that's by now a familiar objective and consistent with the goal of discovering the hypothetical bargain. In practical application, the joint maximization approach asks whether the gains to one party, the grantor of exclusive rights, outweigh the losses to the other party, the agent. Thanks for listening.